And we are live. Welcome to CryptoLaw TV. I'm John Deaton, the founder and your host today. It's been a big week. Silvergate, SVB, Silicon Valley Bank, and Signature Bank. The war on crypto, ladies and gentlemen, is full and in effect. We know that SVB went down, and we know, and I'm not going to get into a debate over bailout versus not bailout, whether or not it was the right political move. What I want to focus on is once the SVB recovery was basically stated and the public became aware, that's great. Depositors got a lending arm, if you will, from the Federal Reserve. But we learned something else. At the same time, we learned that Signature Bank was seized by the government pursuant to state authority. Now, I'm going to tell you that that state authority and the feds are all working together, and there's no doubt about that. And this all started because of U.S. sitting Senator Elizabeth Warren promoted, encouraged, and as far as I'm concerned, completely facilitated a bank run on a bank involved in crypto. And then there's the seizure of Signature, which was the last big bank that was funding crypto. We know that Coinbase and others had shifted from certain banks to Signature. And how do we know that this was a coordinated effort? Well, we have evidence. There's a guy who sits on the board of SVB, of Signature Bank, and his name is Barney Frank. For you young people out there, who is Barney Frank? Barney Frank is a former congressman from Massachusetts. Okay, he is the co-author of the infamous Frank Todd bill, basically, that was the legislation that was initiated from the banking crisis of 2008 and 2009. Well, he sat on the board, and he himself came out and said that this was a message, an anti-crypto message. All right. Now, Barney Frank is very liberal, or at least he was considered liberal many years ago, and always voted with Elizabeth Warren. And it's interesting. I think that we can take his word for it when he says that this was a message. I mean, think about it. Signature was seized. According to the board members, they have more assets than they do liabilities, yet it was seized. And you got to ask yourself why. We have proof. Elizabeth Warren had already had a op-ed for the New York Times that was already prepared and sent to the New York Times prior to the announcement. Okay, and so we know that that's what's going on. The war on crypto, ladies and gentlemen, it's political, it's economic, and it's real. And I've been saying something because I went on record to say we're not going to get legislation until maybe late 2025. It's just a reality. It's not the way it is. It's not the way I want it to be, but it's a reality. And our clarity is going to come from fighting in court. And when the government oversteps its authority, we have to fight, and everyone has to fight. Retail holders have to fight. Investors have to fight. Industries, companies have to fight. And look at what we're winning. We're winning the fight in court. That's for sure. And we have examples. We have Grayscale, a hearing, appellate hearing that just happened. We have Judge Torres's decision on the Dauber motion where she's excluding certain experts that the SEC was trying to call and overstep their bounds. The SEC is trying to exceed its authority. It's not abiding by the law. We have judges coming out, not just Judge Torres, but we have a judge who said they have a faithful allegiance to the law, called them hypocrites in the Ripple case. Then we get to the Voyager Binance deal, and what happens? You have a federal judge calling the SEC out saying, what are you doing coming in here objecting because something might be something that you can't figure out is something? It's just ridiculous. And these are federal judges coming out. And if you look at Grayscale in the hearing, the appellate judges came out and said, you're not bringing any evidence. Everything you said about the lack of controls for manipulation related to a Bitcoin spot market ETF equally applies to the futures ETF. So do you have any evidence? The judges said, you do not claim that Grayscale's analysis is wrong. You just want to object. And so the point I'm making is that each fight we get, we're winning in court, and that's where we've got to keep our focus. And so just recently, some of you know that I put out that I'm putting together a class of ETH holders. I wasn't lying when this all happened 2 years ago. I told people, I said, had the SEC went after Vitalik and Consensus and the Ethereum Foundation, claiming not about the ICO or about the way they sell ETH, but that secondary market sales of ETH are securities as well, I'd have done the same thing I did with XRP. And now we're going to move forward with that. And I know there's a lot of people out there that are falling into the same trap. I want to go back to when the XRP case was filed. Do you remember what the ETH folks and Bitcoin folks said? They focused on Ripple. Remember the complaint? It was a non-fraud complaint against the executives, but they used fraud-like language. They said things like Brad Garlinghouse said he was long XRP, but he sold XRP while he was saying that. And they diverted people's attention, and everyone was saying, why are you doing that, John? Right? Look at what the Ripple founders did. Look at how look how they dumped on the retail, blah, blah, blah. I said, I don't care about Ripple. I care about the token. I care about a government coming in trying to legislate software code as securities. That's what I care about. And I know a lot of you are falling into that trap. Well, ETH had an ICO, but this case in New York doesn't go after the ICO. Okay? Why should you care if you're a crypto holder and you can't stand ETH founders? Well, let's look at a page from the New York Attorney General complaint against the KuCoin exchange. Look what it says. Okay. It's highlighted there for you. ETH holders can now profit merely by participating in staking. If you're an XRP holder, you're a Cardano holder, do you stake with a platform? Do you gain some kind of interest from it? Do you collateralize your ETH or your XRP or your Cardano or any other Bitcoin or anything else? Do you do that? And do you receive a financial benefit? Well, if they're successful in merely implicating ETH because you are allowed to stake it, what do you think they're going to say? This is a coordinated effort. If you go into the further down in the complaint, look how they intentionally group ETH with UST and with Luna. Everyone knows that UST and Luna is now, you think of like maybe fraud, or you think of all the bad things that happened with Luna and UST. Well, there's no distinction here. ETH is right in there. And think about, when I talk about coordination, what I'm getting at, you don't think that the SEC and the New York Attorney General's office is working together, really? You don't think that the Federal Reserve and FDIC and all of them are working together against crypto? This is a coordinated effort. You don't think, and a lot of people say, well, this isn't the SEC saying that ETH is a security, it's the New York. You don't think Gary Gensler, if they get a good result for regulators, if they're able to say, or some kind of judicial finding, dicta language, whatever you want to call it, in the New York case that says ETH was a security or is a security, you don't think Gary Gensler is going to turn around and say, hey, things changed, the merge changed things, and distinguish the Hinman speech? You think he's just going to let it go? Come on. So that's why we have to fight. We have to fight in court. And when I talk about fighting in court, I want to bring on my guest, because that's the real reason why we're having this live cast. And my guest is no other than the great J.W. Verret. Okay, and J.W., welcome to Crypto Law. I appreciate it.
Good to be here, JD.
Well, listen, I read that article in 360 that you just had, and you pointed out some things, and you made I won't say it's a prediction, but you talked about how the Ripple case is going to be decided, and it has huge implications in the law in an appeal situation. Can you explain what you meant?
Yeah. So I had my eye on a case called West Virginia versus EPA. So the Attorney General of West Virginia challenged the EPA's overbroad use of statutory some phrases in its authorizing statute, overbroad use of that statute for a use of power completely not contemplated by the initial statute that gave the EPA authority in something that affected the national economy in a way that requires clear regulatory authority from Congress. Sound familiar? Right? This is a cookie cutter fit for the issues that crypto is facing. So the EPA got slapped in its effort to finalize an Obama administration era rule because it was using old authority that was not clear, not specific, that led to a circumstance where an agency is making a decision that has major political or national economic consequences, but they're using some vague, and underused language from their statute, kind of twisting it to cover that. I think it's a perfect fit. If willing to go the distance, go to SCOTUS, I think Justice Gorsuch and the other justices from the majority opinion would be willing to take a look at crypto and use the SEC's overreach in this area as a vehicle to transform administrative law itself. I think that's what's ahead. It'll take a while, but it is some hope for the future.
For people out there who are thinking about, can you give a time frame before you think that this case? Let's assume a judgment comes down that's appealable from Judge Torres in the next month. How long it would take to get to the Second Circuit in the Supreme Court?
I mean, it could be a 4 or 5 year haul, so it could happen. It could be even longer than the time frame you're thinking of for legislation. But it's good to know that's at least possible, likely. It's good to put that on Gary Gensler's radar and the SEC's radar, so they know that's what's ahead if they don't get reasonable. So I'm going to be out there letting people know about my views on this issue, and letting them know that there's hope if we continue to fight. What they did to library, I know you followed that case. What they did to library was atrocious, man. It was such an overreach of authority for such a, there was no fraud, there was no misrepresentation. This was a small little protocol it was a little engine that could trying to comply with the law. And as a result of their going in and talking to Gary, they got totally decimated. And the SEC's efforts on trying to on the penalty phase were just egregious, man. I've never seen the SEC act that way.
Yeah,
in not allowing for normal expense deductions and stuff.
And I have to tell you, soon I have to wait, but when you see the transcript, and it'll be able to be released from the November hearing, the judge 13, 14 times on the record is telling the SEC, well, at least give clarity to secondary market sales. Like you've conceded in court that maybe a majority of purchasers of the library token are users. They have a non-investment use and intent with it. They're using the token to access the protocol and at least do something. And the SEC literally says to the judge, we don't do that. Like, we're not going to provide guidance. And so that's why I went in there and was like, well, judge, you got to at least make sure that your order specifies and clarifies that it's not applicable to the secondary market. And I bring it up because in your article, and I encourage everyone to read it, we'll make sure we tag it, is that you say that in the Ripple case, it wasn't just initial sales, but it's subsequent sales. And I'm sure you teach this law, but there's not a case since Howey that ever held a subsequent sale of an investment contract scenario was also an investment contract. And so you mentioned something about protocol. Can you comment about, in your article, you say that it's impossible for a DeFi protocol to comply or register the way that the SEC is claiming?
Well, this is the kind of panoply of unreasonable things the SEC is doing. They're trying to treat tokens of decentralized networks as securities. They're also trying to treat DeFi protocols as exchanges and saying that a smart contract where you go to trade a token, swap a token, is itself an exchange. You can't make computer code register as a stock exchange and comply with all the rules of the stock exchange. It takes tens of millions of dollars to stand up a new stock exchange in this country. You can't treat computer code like a stock exchange. So this is one example of a few examples where the SEC is exceeding its statutory authority. When you look to, so I encourage everybody to read West Virginia versus EPA. This is the new conservative majority. Whether you like that politics or not, that's what's going on. It's going to help crypto. Justice Gorsuch has a concurrence in West Virginia versus EPA where he elaborates on what he would like the major questions doctrine to become as a doctrine to kind of peel back the discretion that the administrative state, all these agencies get. It's not binding, but it's a concurrence, and it's his roadmap for what he wants to achieve. I think crypto fits into his roadmap. In other words, I think judges that don't even care about crypto are going to care about these cases because they're a way to transform administrative law and peel back some of the deference that they've gotten through cases like Chevron and others.
Do you have an opinion as to why the SEC picked the fight with Ripple? I mean, Ripple's well funded. You know, Brad Garlinghouse has said publicly that when all said and done, it'd be $100 million in legal fees. That's pretty steep.
Well, I don't think they saw that coming, and I think they probably expected there would be a settlement, and I think they underestimated the fight inside of Brad. There's a lot of sand. I've learned there's a lot of sand inside that fella, and I admire that. And he's doing a service for everyone in crypto.
Let me ask you.
We all ought to shake his hand.
You're much more of an expert on appellate, law and litigation than I am. Do you think that what we're doing as token holders, like in the Ripple case, becoming amicus, will have any impact if it goes up on appeal?
I do. I've always thought that the district court's a tough place to fight. It's worth fighting. They're going to be reluctant to make new law, and Howie has been so flexible in the past that it's a tough fight, uphill fight. But I think appellate and Supreme Court is where we'll really start to make some headway, and where a lot of the nuance of the doctrine becomes more important. Then that's where amicus briefs are so essential, where you can get a bunch of different perspectives. Like, rather than just one way to fight the SEC, you give a judge a menu of 10 different ways to overturn what the SEC is arguing. I think amicus briefs are essential in cases like this. So get the typewriter ready, man. You're going to have to do another one.
Well, thanks. And listen, you were one of I want to say thank you, because one of the first, when this all went down a couple of years ago, you were one of the first people who supported our efforts, you know what I mean, from the token holders perspective. And so you've always been great that way. So let me ask you, J.W., do you think that the courts will be able to rein in the SEC before they do too much damage?
They're gonna continue to do some damage. We'll see if maybe we have more luck quickly on overturning rule proposals. If they move forward with the Reg ATS proposal, that's an attack on DeFi, I think we'll quickly see a challenge to that. The token by token cases, like Wahi and like Ripple, are just going to be long slogs, and they're going to continue to bring them. I just hope that more people are willing to fight, and I will see what happens with Coinbase. The rumors of the SEC circling around, but Coinbase is also big and strong and has some sand in them. So maybe they won't make a full-on run at Coinbase. Hopefully they won't. I don't know that in the short term, it's just more pain. Let's remember that Rocky movie. What's your prediction? Pain.
Pain. Yeah, Mr. T.
That's what the short term. Yeah, that's right, Mr. T. Yeah, what's your prediction? Pain. It's more short-term pain, but in the long term, I do have hope, because I think these doctrines are going to help us, and we're starting to see some light from Judge Rao's questions, as you mentioned, in the Bitcoin ETP Grayscale litigation. So,
what do you think that if Ripple were to get an outright win, do you think that would slow? If Judge Torres comes in and just rejects the SEC's theory because, as you know, the SEC didn't necessarily limit it to just specific transactions that Ripple said that specific offering and sale was a security. But with this, the token itself embodies all the efforts and promises and inducements Ripple made, and XRP itself represents a common enterprise and also, the expectation of profits. If she just flat out rejects their theory, and do you think that will be a big slowdown? Or do you think Gary's just going to say facts and circumstances and move on to the next
one? That would be a big win. That might slow him down. I think if it's more of a win on the fair notice argument alone, because you could see a judge seeing an easy way to kind of resolve the case, just focusing there. That would obviously have a lot less implications for all the other follow-on cases. And I think the SEC would be unlikely to challenge that. If they lose on that, it doesn't cause precedential issues for them in other cases, so they might just let that lie. But if it's a bigger win, then the SEC is going to quickly appeal it, and they're certain to appeal it. So in some sense, if you're a Ripple holder, you almost want an XRP holder, because they're very different. If you're an XRP holder, you almost want a very thin win. You want a win on fair notice alone, I guess.
Now, in your article, you said more cases are imminently expected. I've talked to a couple projects that are currently in subpoenas activity with the SEC. I've heard a rumor of a couple hundred potential enforcement actions being filed in the next couple of years. I mean, do you have any insight on or information that supports that, rejects that rumor?
I know there are lots of inquiries. I don't know when the Wells notice is going to go out. It's hard to tell. They're keeping a lot of that close to the vest, but it wouldn't surprise me.
Let me ask you. I said this. You tell me. People ask, why do you think the SEC's, doing what they're doing? And I have a theory, and it's shared by some people. I don't know by you, but I have this theory that the agenda is to crush crypto and to allow incumbents to come in and get a bigger slice of the infrastructure, get a bigger slice of retail, whatever it is. And I don't know, because sometimes it's hard to try to rationalize what appears to be irrational, but that's the theory I'm sticking with. I don't know if you have any thoughts on that, because it just doesn't seem like I can come up with a better example or a better explanation as to why they're this set against crypto.
Yeah, in 2017, a lot of the ICOs there was a lot of junk ICOs along with some really great ones, and that probably motivated it then. And then when it transitions to Gensler, I think the politics just favored him. The more looks like he's tough on crypto, the more the politics favors him. His hard progressive political backers favor him, and that gets easier and easier post FTX. So he knows better than the kind of obsequious statements he says. Just come and register. It's just one form. Just fill out the form, as if that's easy. He knows better than that. But he also knows that the simple obsequious kind of talking points sell politically. So he just keeps doing that. And every securities lawyer I know looks at him, even the ones that are very pro-SEC enforcement, look at him and say, wow, we've never heard a chairman talk like that. That's more politician than chairman. But, he doesn't care what securities lawyers think about him. He just cares about the politics, I think.
Well, what do you see? My final question to you really is, what do you see the next year looking like with crypto?
I think there's, like I said, I think there's more pain. I hope for a Ripple win. I think either way, it probably keeps going. And we start sharpening our knives on amicus briefs to get involved in that fight. I think it's going to be more cases. I think they're going to continue to get ready to ramp up the Reg ATS proposal to come after DeFi. And I think it's a multi-regulator front. I mean, the banking stuff is as bad for XRP and Ripple as it is for anybody else. The choke point 2.0 stuff. We have yet to really hear from the IRS, but the IRS is going to start tracking all of our transactions on chain, unless it's privacy coins, and they're going to start sending us, John Doe summonses to ISP providers like they do to exchanges. So I think the IA and we haven't heard from the CFPB yet. Wait till they enter the fight. Wait till the CFPB enters the chat and says everything is consumer finance. So there's going to be a multi-front war. And then if there's political change, either Senate flips and the D's pick a moderate to replace Gary, or it switches to Republican control of the executive, then it could be rays of hope quickly. And that's a better time. I think we just have to survive, man, between now and then.
All right. Well, JD, where can everyone find you that's watching or sees this clip?
So I'm on Twitter at J.W. Verret. And let me know if I can help you out. I also do some practice defending people before the SEC. I'm a practicing securities. So if you need help, let me know.
Well, I have a couple. I may be giving your name out a little bit because I'm getting calls quite often now. So listen, thanks for coming aboard. It's always a pleasure. Keep up doing what you're doing, brother.
You too, my man.
Thank you. All right, that's it for tonight. The point is, or today, it's been a long day already, but the point is you have to be prepared for the long fight. And out there, even if you hate ETH and you're a New Yorker and you want to join that fight, join the fight, because we're going to have to fight day in and day out. With that said, have a good night.